Rebuttal, Mr. Shanmugam.
Thank you, Mr. Chief Justice. I'd like to cover the relevant preemption principles, talk a little bit about the cases, and then finally talk about the practical consequences. My friend Mr. Kneedler says that this is, quote, preemption of a sort. Well, it can't be that. It has to be some form of preemption that this court has recognized, and it seems to us that there are three possibilities. The first is obviously conflict preemption, and my friend Mr. Schauf talked only about the General Crimes Act. With respect to my friend Mr. Kneedler, we do think that this court's decision in Wilson resolves this issue for the simple reason that it says in the second half of the relevant sentence that the phrase within the sole and exclusive jurisdiction of the United States is only used in the description of the laws which are extended to it. We think that that's correct as a matter of statutory interpretation because the statute talks only about the general laws of the United States extending to Indian country. And to the extent that my friend Mr. Schauf talks about a background principle in the soil, the principle at issue is a constitutional principle. It's the principle from the Enclaves Clause in Article 1, Section 8. And I think it would be quite strange, given the structure of that provision, to say that it incorporates that principle as well. And if it did, it would suggest that McBratney itself was incorrectly decided. And to the extent that finding no footing in the text of the General Crimes Act, my friends turn to the Major Crimes Act, we think that the proper way to construe the Major Crimes Act is as indicating that an Indian who commits a crime that is enumerated is subject to prosecution within the exclusive jurisdiction of the United States, not simply that such an individual is subjected to the same punishment as an individual who commits a crime within federal enclaves. This court's decisions in John and Nagansett relied on the text of the statute, albeit without much explanation, and that's even clearer when you look at the earlier versions of the two statutes which we cite in our reply brief. As to Public Law 280, the argument that my friend Mr. Schauf is making today really does sound in field preemption, and I would respectfully submit that Public Law 280 comes nowhere near the standard for field preemption, which requires a framework of regulation so comprehensive that Congress left no room for the states to supplement it, and a federal interest that is so dominant that the federal system can be assumed to preclude state laws. That's the Arizona versus United States test, and that would be a very odd test to say is satisfied in an area where the state has presumptive predominant police power. Finally, with regard to balancing, the language on which Mr. Schauf relied from Mescalero talks about how the ordinary preemption framework often doesn't operate where there's a tribal interest. But what Mr. Schauf omits is that the court says that when that is true, the court resorts to balancing. And we haven't heard a lot today about how respondent could prevail under that balancing test, and I would respectfully submit that that is because he cannot. With regard to the cases, I would just say with regard to Donnelly that my friend Mr. Kneedler said that Donnelly settled this question. If that's true, I'm a little bit perplexed as to how the federal government could have taken the opposite view on the question presented in the OLC opinion and thereafter for a time and characterized the language in earlier cases as dicta. But the one thing we can be certain about Donnelly is that it did not say that the states lacked jurisdiction. Donnelly simply said that the federal government had jurisdiction. It said that the question was whether or not the states had, quote, undivided authority over that category of offenses. And in doing so, the court repeated and endorsed the language from Wilson to which I referred earlier. Finally, with regard to the practical consequences here, my friend Mr. Kneedler said that he was not here to minimize the problem on the ground in Oklahoma, but he was not exactly eager to tell you about the problem. And I think that the problem with respect is greater than he suggested. He referred to a number for the number of cases where convictions have been overturned in the wake of McGirt. But the far bigger problem is the ongoing prospective law enforcement problem in the state of Oklahoma. And contrary to Mr. Kneedler's suggestion that cases are simply being held in the queue, I would refer the court to DOJ's fiscal year 2023 budget request, where DOJ said, and I'm quoting, as enforcement of nonviolent crime is relatively low, Oklahoma communities may see a surge in such crimes, and many people may not be held accountable for their criminal conduct due to resource constraints. So to answer your question, Justice Alito, is this a sustainable situation? I would respectfully submit that it is not a sustainable situation. And it would be a cruel irony if the consequence of this court's decision in McGirt is less protection for the tribal victims of serious crimes. We would submit that the judgment of the Oklahoma Court of Criminal Appeals should be reversed. Thank you.